I'm Eloise Scotford. I'm the Dean. It's my absolute pleasure to welcome you all to Bentham House for a very special occasion this evening, about which I am very excited. And I'm going to give you a couple of words on why I'm very excited about tonight's event before I hand over to the people who are in charge. There's been a lot of thinking and serendipity and strategy to get to this moment where we in a law school are putting mediation front and centre in some of our activity. And I'm really, really delighted that we're doing that. This is my fourth year as Dean. And I remember my first year sitting down with John Sarabji and then a little bit with David Ormerod, some of my excellent colleagues, saying, we do lots of brilliant stuff in the space of dispute resolution, or we might define that space in a number of different ways, actually. We also do a lot of incredible work in access to justice. We're an inclusive law school. We have our Centre for Access to Justice. And all of these things, we tend to have the people who are the best in the field. I feel like we might want to connect these dots and join these dots a little bit more, because it's fundamental to our mission as a law school that we're a place that understands the practice of law and lives and investigates the fundamental ideas around access to justice and our court system and our justice system. Kind of now more, and I'm sure all of you will know this in the room, there are so many pressures on our justice system and our systems for dispute resolution that this needed to be an even more important focus in what we do in the law school. And in the context of those discussions, not only did we think a bit more about what is now has turned into our exciting new Centre for Dispute Resolution, but enter Anna Howard as a very important element in this. This is where a bit of the serendipity comes. We knew that we had a bit of a gap in the mediation space, and almost like John's World of Civil Procedure, there's not that many academics who do these things, but when they do, they're absolutely fantastic. The connection between practice and kind of the research and thinking around these things. Then Anna emerges. And I was like, there we go. There is someone who understands the interface between practice and the academy in the space of mediation. And that felt like a really important part of the puzzle. Then a bit more serendipity. I'm at the Dennis Holland dinner, maybe 2 years ago, and I was sat next to Michel Kallipetis. And we get talking. And I said, so what do you do? And it turns out he's one of the most eminent people of mediation in this country. And he's also one of ours. He's a UCL alumnus. And I'm sitting there, I said, I keep talking about mediation, Michel. He said, well, so do I. That's what I do. And he said, well, maybe one day I'll come back. And I said, we're going to do more. We're going to do more. And I'm super excited. Anyway, the result of all of these things, my job is just to kind of join dots a bit, but also to express a bit what are the emerging priorities and the energy that's gone into those different strands, a bit of strategy, a bit of effort, is that we're now actually a law school that is doing mediation. We're training our LLM students. We have a program where we bring that into the classroom. We're teaching them more about it. The demand is strong. The students love it, and we're connecting with you as a community. And now we're joining with one of the most esteemed organisations, the Civil Mediation Council, to work together. I could not be more delighted. There is a lot of things that have come together in a very beautiful way this evening. And that's all I will say, because I'm going to hand over to everyone who's involved to just to say I'm so thrilled and welcome, and I hope it's a fantastic event. I'm going to sit here and enjoy it myself.
Thank you so much, Eloise. And just to say, really the enthusiasm and appreciation right back at the UCL team, frankly, we really would like to take the opportunity to thank the UCL team, the law school and specifically the Centre for Dispute Resolution for hosting this lecture in partnership with us, the Civil Mediation Council. It is our first academic lecture. We're very proud of that. Apart from the fact that Anna and John have been an absolute delight to work with, we also wanted to highlight really that UCL is such a good place to have our first lecture because of all the work and the experience that you have. I'm not going to go over all of those wonderful points that you said about Anna and John, but absolutely all of those. And the Centre does have a real focus on mediation, which is something that we really want to support. And as you say, Michel is, of course, a proud alumnus of UCL. You might be forgiven for thinking that it's a bit pointless for me to introduce Michel. Bearing in mind he is one of the most highly regarded and best mediators in our profession, and I'm sure absolutely every one of you in the room knows him, and everybody online also knows him too. That said, I just want to share with you a snapshot a tiny snapshot of his expertise because it's quite extraordinary. Michel has over 40 years' experience as a barrister, specialising in commercial law, professional negligence and employment. He's the former head of Littleton Chambers. He also served for more than a decade as a recorder and deputy High Court judge in the Queen's Bench, the Chancery Division and the Technology and Construction Courts. Slightly less well known is that even prior to doing his law degree, Michel was a qualified auditor with the Exchequer and Audit Department, which is now the National Audit Office. Michel has mediated over 1,750 cases in almost every sector of business and law in the UK and internationally. He is quite rightfully recognised everywhere for his expertise. The legal directories, he was Lexology Index's Mediator of the Year, both 2017 and in 2020, and he was named as a Global Elite Thought Leader in mediation. He is a distinguished fellow and past president of the International Academy of Mediators, and he was recently honoured by them with its Lifetime Achievement Award. He was the first chair of the Bar Council ADR Committee. He's on the Singapore Mediation Centre's International Panel of Mediators, the Hong Kong HKIAC Accredited Mediator Panel. And in 2024, his outstanding contributions were further recognised when he received the Worldwide Mediation Pioneer Award at a global mediation festival in Greece. I'd just like to reflect that over his career, Michel has been really instrumental in influencing policy on mediation in particular. He was a member of the Working Party, which drafted the EU Code of Practice for Mediators, which of course we at the CMC adopt. And he gave his expert opinion to the Legal Services Committee of the European Parliament prior to its adopting the European ADR Direct. He was appointed observer for IAM and CIR by the UNCITRAL Working Group on what is now the Singapore Convention. Michel's bio very modestly says that he acted as counsel in the Court of Appeal in Churchill. And I just want to say that it's true for certainly the CMC and possibly many others who were involved, that but for Michel, none of us would have been there intervening as we did. So Michel was behind the scenes working tirelessly to make sure that mediation was properly represented there. And it's something that I'm certainly thankful for having the opportunity to work with him on it. Michel has, I think, long advocated for mediation privilege to be recognised, and I'm sure we are all looking forward to having the benefit of Michel's wisdom on this topic this evening.
Thank you very much, Kelly. It's very embarrassing in such a room full of stars, most of whom I know, and all of you are past masters in mediation. And I'm not an academic. This is a practical lecture designed to generate a debate. In the last 25 years or so, since the Wolf reforms changed CPR and made the overriding objective the forefront and litigation as a last resort, right through to Churchill, the legal scenery for resolution of disputes has changed dramatically. I mean, it used to be called ADR, alternative, and then solicitors got wise to the fact that it was more than just an alternative, so all the departments became litigation services, dispute resolution. And then ultimately, after Churchill, it is now recognized as part of the mainstream of our litigation fundament. And so it should be. Now, all of you who mediate will probably know all that I'm going to say this evening, so bear with me. There's a fairly hefty tome, which I'm not going to read to you, you'll be happy to know, but you can collect one on your way out if you're really so sad and need some entertainment. But I'm very grateful to two postgrad students from my old college, Athena Kam, who's here, and Siva Shavashankar, who's, I think, here too. They did some research for me. And in fact, we have a whole pile of research for looking at the other jurisdictions and how they approach mediation in general, and mediation or confidentiality in particular. There's not time or room to put them all in this, so it may well be there'll be a second version sometime online when we get that all together. But throughout the 25 years, although mediation became more and more part of dispute resolution, there's one particular subject that remained throughout unresolved, And that is the precise nature of mediation, and whether the time has come for the courts to recognise that mediation should be accorded its own separate and distinct privilege. I hope this lecture will generate a debate among practitioners. It's been going on amongst academics for some time, notably quite recently from a Professor Ahmed in Leicester, who wrote an article only 2 or 3 weeks ago, referring to the fact that the latest decision, the judge referred to no mediation privilege, ... as yet, and propounding that there should be serious consideration given to the question, and referring to the magnificent article by Michael Briggs, which I shall refer to in a bit later on. Now, the way that I structured it, as I'm not going to read this thing to you, what I will do is take highlights to try and highlight what I think are the important things. All of you who mediate, and I know that most of you do here, will have a contract with the parties for mediation. And every contract that I'm aware of invariably includes a clause where the parties agree that they and the mediator shall keep confidential and regard as privileged, and shall not use any information of any nature produced for or arising in or connection with the mediation, save as may be necessary to implement and or enforce any settlement, and or as may be required by law, and or to professional advisors, insurers, reinsurers, etc., if strictly necessary and under the same terms of confidentiality. They also undertake in the contract to keep confidential and regard as privileged, and shall not use what happened and what was said at the mediation and the terms of any settlement, unless the settlement has its own confidentiality clause, as most of them do. And lastly, all documents or information created purely for the purposes of mediation are privileged and will not be used outside the mediation, unless, of course, they will be disclosable in any event, in the event of litigation. Now, I suspect, in common with each of you who mediates, start my mediations by seeing parties privately and explain to them that the whole process is, as far as I'm concerned, privileged. And I go on to make it clearer. I say that means that nothing anybody says in the mediation, no figures agreed or suggestions made, can be used outside the mediation without everybody else's written consent. I learned how to do that because I was doing a mediation in Scotland, and it was a dispute involving trade unions in Glasgow. And to my surprise and somewhat dismay, after lunch, somebody produced the afternoon version of the evening paper, and there was a blow-by-blow account of the mediation that happened in the morning, because one of the trade union officials didn't know it was confidential. So I make sure now that every single person who's in the mediation signs the agreement accepting the confidentiality privileges, and also that I explain exactly what that means. And all of you will know that the correspondence we get from solicitors and anybody who wants to book us for mediation, they use the word privilege on the letter without prejudice and mediation privilege. So it must mean something. Courts have a difficulty, and I don't quite know why. In the early days, I think the difficulty was understandable because mediation was not well known among judges. I remember when I did Halsey and Milton Keynes with Lord Justice Dyson, John Laws, and what's the third one? Matthew. I got them to write in their notebooks the famous north-south line: rights, remedies, needs, wishes. And they were just drawing into their notebook, and that explained to them what mediation was about. These days, most judges have either had mediation training, some of them have been mediators, and all of them are aware of what mediation is about. But it hasn't changed their view, but they just can't resist wanting to know a bit more about what went on. Now, I understand there's the two public policies. One is that people should be encouraged to settle their disputes and to make it easy to enable them to do that. They are cloaked with a privilege that protects them. So they are able to be frank, able even to make admissions, able to make suggestions without fear that that's going to come back and bite them if they don't settle and the matter ends up in court. And the other is the judge's obligation to try cases with all the available evidence that's there for them to see. And bridging those two public policy principles sometimes is difficult. And the temptation just to have a little peek under the curtain is almost irresistible. And we will see a bit later on cases where you all know of where this has happened, and bit by bit, with all due respect to their lordships, people have nibbled at the corners, and now there are at least half a dozen, probably more cases where the courts have extended the principles in Procter and Gamble about when the court is entitled to look into mediation. Now, one of the problems is that there's no actual agreed definition either of mediation or indeed mediator. There we are. So you see there that there's a definition in the London Chamber of Arbitration and Mediation, defining mediation as a flexible and confidential process used to settle a dispute between two or more parties, and read the rest of it. And then we have various statutory and non-statutory definitions. Mediation, the Family Law Act, mediation defined in the CPR, and also in the government guidance, mediator is a neutral third party who will attempt to facilitate negotiation by the parties of an agreed settlement. And lastly, in LASPO, they describe mediation as one of the assistances that's available for punishment of offenders. So they're not all the same. And then for the purposes of the definition of mediation, not because I was part of the party that drafted it, but I think one of the best definitions is in the European Code of Conduct, which you see on the board there. It's a process process is an important word, where two or more parties agree to the appointment of a third party, hereafter called the mediator, to help the parties to solve a dispute by reaching an agreement without adjudication, and regardless of how that process may be called or commonly referred to in member states. I would suggest that these are the requirements of any definition. For mediation privilege, the basic necessities. It's a process, not a period of time, a process. There's a contract in writing to appoint a neutral third party to act as mediator to help them to a resolution in accordance with the terms of the written contract. And the written contract must contain all the requirements of neutrality, impartiality, and independence. And most importantly, for reasons I shall come to later, any settlement must be in writing and signed by all disputants. And so, if I'm going that, one of my colleagues describes mediation, his role, as follows: providing consultancy services to each party aimed at ensuring that they make the best of the process and make the highest quality decision at the end of the process. And I would want that consultancy exchange between me and any party or advisor to be protected in order to attract full engagement. And that, of course, is the requirement of a successful mediation. It's a full engagement by all the parties, as lawyers, experts, if they're there, and the parties themselves. And the one issue that's always being mentioned is, am I safe? Is any of this ever going to be looked at later? And unless one can assure the parties, the lawyers mostly, I think, recognize it, then it's impossible, because human nature, of its very essence, will protect itself in positions where that person knows they are at risk. And mediation is a risk. The way that people commit to it, the way that people open up in a mediation puts them at risk. And that's why simply calling it assisted without prejudice negotiations, or worse still, as one judge described it, simply an ad hoc go-between, is not only offensive, it also misses the whole point of what mediators do. The common law countries are divided as to how they view it. Some jurisdictions regard it simply as merely assisted WP negotiations following the Procter & Gamble line. Others consider the mediation has an entirely separate privilege all of its own. And the difficulty with the first approach, of course, is that it's open to all the challenges which we're familiar with in WP negotiation. And the latter case, which is the opposite end of the spectrum, notably in California, nothing that goes on in mediation is permissible in court. Even a suit against one's own lawyer. It's one dreadful case. The lawyer had his client up against the wall with his hand around his throat saying, "You'll sign." And he sued later, and the California Supreme Court said, "No, we're not admitting it." So he couldn't prove his case. Now, that is obviously the opposite end of the extreme and not one that anybody in the right senses would advocate. So, do we need a distinct mediation privilege? We do for many reasons. I've already mentioned the two balancing conflicting interests, but mediation in the last quarter of a century has changed. I know that I did a debate with one of my colleagues, head of another set of chambers, who wasn't very much in favor of mediation. And he was rather dismissive, saying, "Oh, deal is what's important. Cutting a deal is all important. You're not interested in anything else. Deal's the thing." Wrong, of course. But even that attitude has changed over the years as far as mediation is concerned. It is now what I call a holistic process. It's designed and we operate to resolve disputes, not just get a deal. Deal is probably the last thing initially. And I'm not talking about commercial organizations that are suing each other for millions and millions. I mean, they can take care of themselves. The mediations which I think disturb us most and where a privilege is most needed are where individuals are going to be the people who are going to suffer at the end of the day. They're suffering enough anyway by being in dispute, usually. They're suffering when they see the costs that they have to put on the table to get the lawyers to act. And they're suffering because they know what's coming down the line. And that's why we spend time with parties separately, on their own, speaking to them. And as we're using the words of Michael Briggs, and what an excellent article that is, we should come to in a moment. They unburden themselves. They tell us their secret wishes and desires, their fears, and often things that perhaps one didn't want to know, but they want to share them. And that's the problem. We all know that when clients go to a solicitor with a case, he wants to tell his story. He needs to pour out what happened. That's not relevant. Just give me the facts. No, that won't be visible. No, and there's a feeling of frustration by the time they come to mediation. And time again, I'm sure each one of you has had it. If you have feedback forms, he listened. For the first time, somebody listened to me. And that's the start of what I regard as the essential element of mediation today. And equally, mediation has spread to so many types of dispute. From straightforward commercial disputes, it's now in the family law, in children's custody, guardianship, it's in defamation. There isn't a single area of law, except possibly, and even there, the administrative court is actively promoting mediation. But if it involves the state and somebody's rights or citizenship under the state, that might be more difficult, but not incapable. And no dispute is incapable of resolution if the parties want to resolve it. And sometimes they don't know they want to resolve it. And that's where we come in, talking to them and not persuading them to, just pointing out where a possible resolution might lie. Once we know what their needs and wishes are, what their fears are, and what things they've told us in private. Now, Michael Briggs, in this excellent article, advocates what he calls a privilege for mediation secrets. That's what a mediator learns in caucus with the clients alone, and which he promises never to share with the other side unless it's authorized. And he thinks that is a sufficient privilege. With all due respect to Michael, who's a very good friend, I think that is no longer apposite for today's mediation. Because what do? We get given this information. We have a long discussion with the clients, and indeed the lawyer sometimes. And then they want us to use that information without actually imparting it. So when we go to see the other side, does that privilege run then? We sometimes, in plenary session, when everybody's present, use the information in a way to try and steer the discussion or the impression to the place where we think it might be more beneficial to both parties. Is that going to be covered by privilege? It will be absurd to have, shut the door of a party's room as privilege, you're in the open room no longer, and the court can look into it. And there's, I think, a passage from Lord Griffiths in Rush and Tompkins, where he said to dissect out identifiable admissions and withhold protection from the rest of without prejudice communications, except for special reason, would not only create huge practical difficulties, but would be contrary to the underlying objective of giving protection to the parties, in inverted commas, to speak freely about all the issues in litigation, both factual and legal, when seeking a compromise, and for the purpose of establishing a compromise, admitting certain facts. Now that was in 1989. It's picked up subsequently in Procter & Gamble by Lord Justice Walker, quoting it. And so I think judges do recognize that trying to chop the period of mediation, the conversations, this is privilege, that's not, would be absurd. And it'd be so legalistic. You'd be constantly looking over your shoulder. Hang on a second. If I say that, is that going to make it privileged, or is it going to blow the privilege? I mean, nobody can operate in that sort of atmosphere. But why do we need it? We need it, in my respectful submission, because the WP negotiation privilege is not sufficient. It's not sufficient because it is open to the 6 exceptions to the rule that Justice Walker adumbrated in Procter & Gamble. And you all know what they are. And 3 of them are open to, with the greatest respect, abuse. The first is the suggestion that undue influence. And I'll come back to that in a moment. The second is this wonderful phrase, unambiguous impropriety. Well, it first came to light in an unreported case by Lenny Hoffman, and then subsequently got a lot of traction. And of course, it's a wonderful cloak. Anything can be unambiguous impropriety if you want it to be, but it's a way into the mediation privilege. And lastly, of course, is the interest of justice. Now, justice goes 2 ways, but it's a good let out with the overriding objective, do justice. Judges can use that. And sometimes it's difficult to see why the Court of Appeal doesn't recognize that that is simply a way into a mediation which otherwise wouldn't be available. But if the whole process was privileged, once privileged, always privileged. We learned that in first-year school. So it would never be waived unless by the parties themselves, or if there was fraud, or if there was undue influence, then it doesn't acquire privilege. A person committing fraud can't claim privilege, and fraud undoes it in any event. And a bit later on, I suggest what might be an ideal way of dealing with it, as and when we come to the idea of the courts accepting that mediation does have a separate and distinct need for a separate protection, not simply WP negotiation. This, to my mind, illustrates negotiation. First World War, trenches from Belgium right across Europe to Switzerland. On one side, on the other side, our side. That's negotiation. Everybody's in their trench, feet firmly inside, and you don't put your head above the parapet because you know what happens to it. Now, the idea of somebody, volunteer, independent, assisted by going into no man's land between the two, we all know what happens with the idiot who goes to no man's land, doesn't he? They're going to get shot by both sides at the same time. What mediation is about, if you all remember, none of you here are old enough, in the First World War, the first Christmas, when it was all going to be over by Christmas, and it wasn't. And the German army in their trenches started singing carols, and the British army sang their songs back. Somewhat ruder, I think, to start off with, but ultimately friendly. And what happens Christmas Day, they're all playing football together. Now that, to my mind, is what mediation is about. The art of the mediator is to get people out of the trenches and into no man's land with the opposition. And the magic about mediation, there's no magic in terms of waving a magic wand and producing a solution. The magic is seeing people who haven't spoken to each other, except through solicitors. People who've only been rude to each other whenever they met. People who've been nursing a grudge, sometimes for years, nursing a fear. And sometimes even, in so many family cases I've done, hatred, which is awful to see. But to get them through that, where they are actually speaking to each other, is the achievement of what I call mediation magic. But how do we achieve that? We only achieve it if we can assure people when we're speaking to them privately, you're safe. Not tell me everything. Don't need to do that. They want to tell you. But you have to assure them at the very beginning that it won't be repeated, it won't be exposed, it won't be a matter for court proceedings later. I'm going to give you two cases which illustrate how powerful that can be and why it's so essential. Obviously, if I made them as anonymous as I can so as not to identify them. But remember several years ago doing a case where a chap in Brixton was having a drink after work, perfectly natural, and a fight broke out outside, and he went outside to try and stop it. And he got knocked to the ground and bashed his head on the curb. And the police came, and because he was injured with a head injury, he was taken to the hospital. Unknown to anybody in the hospital, they didn't know the circumstances. Because he had a concussion and ultimately a more serious condition, he became very obstreperous, difficult to handle. And Friday night, emergency, casualty, E&A, please get him out of here. We can't cope, we can't manage it. So the police sent a wagon up from the police station, again, not knowing the circumstances, arrested him, threw him in the back of the van, took him down to the neck, and when they opened the door, he was slumped in a corner. And I kid you not, but remember, this is the days pre-Macpherson's finding about institutionalized racism. The notebook, they do that sometimes to make it more difficult to arrest them. So they dragged them out of the van, dragged him into the station. By this stage, he was doubly incontinent, and they just dumped him on the charge room floor, left him, and he choked to death. Then the police went round to his house. And they didn't say what had happened. They started asking the two sons, who were then, I think, 11 and 12, questions about their father. Obviously, I mean, we all know, because those of us, we all did crime in our junior days, where the natural reaction to you're in trouble is to try and concoct a defense, self-defense, or something's being difficult, so we had to do it. And eventually they came to what happened and told them their father was dead. Well, the disciplinary proceedings came to nothing. I think one chap got a warning. The inquest said a death by misadventure. And so the estate sued the Met on behalf of the children. And I had this mediation to do. And I saw the police, and there were 5 of them. 4 of them had since left the force. 1 was still there. And they said, we really want to see those boys. Why? Well, saying sorry sounds awful, but we really want to express how we feel if we can. Now, leaving aside my views, it was quite clear that they needed to have that sort of release. And it was genuine. The boys are the opposite. They're terrified. The solicitor said, they're not seeing the police, Michel. They've been lied to, they've been deceived, they've been cheated. There's no way I'm going to submit them to that. The boys are now in their late teens. So I spent a good 2 hours with both sides, assuring them that it would all be safe. Nothing anybody said could be used outside. It would never be. Just give it a chance. And ultimately, the boys' solicitor agreed, 1 policeman at a time with 1 solicitor, nobody else. Fine. So in came the first officer, and I must say that using my position, I did choose who was going to go first and who was going to go last. First officer came in, he left the force, and sat opposite the boys, who looked at him, and he started to say, just want to say, I'm sorry. And the eldest boy said, why did you let my father die? Hell of a question. And the officer said, or the ex-officer said, I've been asking myself that question ever since it happened. I can't tell you. I can't explain why I went against all my training and didn't look after your father as I should have done. I'd like to say I know how you feel, but I know I can't possibly. I just want you to know that I have thought about that every day since that night. The second officer came in, and the same thing happened. And bit by bit, as the third and the fourth officer came in, or ex-officers, you see the boys actually physically growing in stature, growing in confidence. And when the last officer came in, who stood in the force and tried to justify, so well, it was a procedure, they laughed at him. And that was just absolutely wonderful, because they went out of there proud. They shook my hand and said, thank you. We are now restored. Now that's mediation today. We do that in every single dispute we mediate. We restore people to where they should be before they got into the problem which they're litigating. We give them back their self-respect if we can. And if it results in a settlement, as it usually does, then well and good. But the most important thing is the care for the people who are going to be most affected. It applies equally to large commercial organizations, where usually 1 person or 2 people are going to be at the wrong end of the complaint if they lose the case. And we've all seen it too. Fairly senior people in a large bank, deep down terrified, because either they know they've made a mistake, or they're going to be blamed, and they want to somehow get that off their chest without being fired and without it ever being made public. But that sort of meeting would be impossible if we weren't able as mediators to assure those we want to take part in it and fully engage in it, to trust us when we say, you're safe. If there's a privilege, there'll be no problem. Everybody would know that the whole thing was covered by privilege. And only somebody's almost criminal act would in fact blow that. The other case was because sometimes it's not quite so dramatic or tragic. They all are, you've all had them, I know. But I was doing a case involving a family company, which seems to be the thing to do these days, is have a row between siblings and father and mother over who shares and who's going to take over the company. Is father going to retire? No, he's not. And younger son, well, I want to break out. And then before you know where they are, they're in a petition to the company's court, and there's a full-scale blown war going on. Families splitting around into sections and costs running up. So first train up to Leeds is pretty grim in the morning. The what's called the light breakfast passes for anything they like. Coffee and tea look the same, and the toast is past its best. There we are. I arrived at the mediation and I greet the father, who's the founder of the firm. Good morning, Mr. So-and-so. Mr. Kallipetis, I'm not paying for treacherous behaviour. Oh, this section 459 petition. I'm not paying for perfidy. Right, this is going to be a good mediation. And you go in, younger son says, morning, Dad. This is a fine bloody hole you dug for yourself, isn't it? And all through the plenary session, everything the younger son said, father was pretty abusive, and mother, bless her, was sitting there knitting going. And she happened to be together with eldest son, the majority shareholder, but didn't say a word. Well, by lunchtime, I was trying to work out how I could say that I have to go back to London. And the chief finance officer sidled over to me, said, Michel, can I have a word with you privately? I said, yeah. Won't go anywhere else, he said. I said, no. I'm going to question if you're getting out. I said, no. Have you noticed a bit of tension between younger son and father? Yes, I have. I said, do you know why? I said, no. He said, do you want to know why? I said, what if it helps? And he said, younger son has pinched father's fancy piece from the typing pool and is going to marry her. So that was the dispute, and that was the driver, and that was the cause of all the aggravation. And so I knew then I couldn't use the information, obviously, and wouldn't want to. But I knew that I had to somehow isolate the father to get this done. Because I could see the sons had agreed between themselves, and I thought mother probably was on side, but I wasn't sure. So I asked one of them, is there any way my father perhaps can go for a cigarette or something? And they said, well, better than that. I said, he's got to do so-and-so, so we tell him to go now. So off he went. And so we got together, the solicitors drawn up all the papers for him to resign and to retire, shares all done. And then back came Papa and all the documents. We'll let you sort that out, Michel. I thought, thank you very much indeed. So I started to explain what they had done and what he wanted him to do. And of course he started absolutely furious and shouting. And Mum, bless her, for the first time in the whole mediation, shut up, Henry, sign there. And he started to bluster. You signed that agreement. It's about time you retired. And you can take me on that world cruise you've been promised me for the last 10 years, and it'll keep you out of the typing pool. Wonderful. So she knew all along, thank God. So, but again, that's mediation can be fun. That was quite funny, provided not involved. But again, that would have been impossible if I didn't. The CFO, he's not. It wouldn't be WP negotiations for settlement because he's not a party. He's the finance officer. So you can't say that's legal privilege. If that sort of conversation could not be protected by privilege, it would never have happened. If it hadn't have happened, I wouldn't have known that the key to it was to get rid of father somehow and get it all done. Simple, possibly trite, but nonetheless an example of why we need it. And I'm going to show the last one too, because it is one that is particularly poignant. Young girl of 18 fell into the clutches of an older and abusive man. She got pregnant. He tried to give her an abortion. She refused. And he assaulted her, beat her up, everything else. Ultimately, the baby was born. He then turned attention to the baby. And one day, this baby was then only 6 weeks old, was so badly assaulted that ended up in hospital and ended up with cerebral palsy, doubly incontinent, unable to speak. I mean, dreadful. The 18-year-old couldn't cope. The father was sent to prison, thank God. And so the child went into care. And after a few years, the local authority gave him a foster mother. And his foster mother was an absolute saint. She devoted the rest of her life to this boy, 24/7, at the expense, in fact, of her own family. And he had been given £2 million from the Criminal Injury Compensation Board for his future education and everything else. And the trustee said one day, look, she wanted to adopt him, and the council said, no, because of his condition, we want to keep an eye on him. But the trustee of the fund said, I think we better get you a statutory will just to protect your position. And 2 weeks before the application was due to be heard, the boy, now aged 20, caught a fever and died. Died intestate, and as you know, that meant his estate goes to his natural parents. Father, fortunately, was disqualified by the court, but the mother had not seen her boy since the day he was taken from her. Wanted the money, said it's mine. She had her own family. She was supported by lawyers who said, no, that's the law, it's hers. Arguments that the natural mother rights would be subjugated to the foster mother, and all the judge got to do is to find that the care she gave, for which she was paid, was far more than what she was actually paid for. Therefore, she has an equitable claim to it. Didn't wash. And so we had this situation, which we all so often happen, absolute deadlock between the lawyers. No possible way that either side were going to give way. And as we all do sometimes, we say, well, I wonder if the two mothers would mind having a word with each other and me. The solicitors were a bit dubious about it, but persuaded them. So nothing can be recorded. It'll never be known. They're perfectly safe. And you know there'll be no deal unless it's in writing, so there's no question of them behind your back agreeing something. Now, when I read the papers, the impression I had of the foster mother was of a saint, and of the natural mother naturally think, well, how callous, she didn't even bother to see her baby. Meeting them was totally different. And I had long talks with the natural mother and long talks, of course, with the foster mother. And I thought that it might work if they explained to each other their positions. So I had the two mothers in the same room. And I asked the foster mother, could you just describe 1 week looking after the boy? And she did. Waking him, washing him, dealing with his toilet, everything 24/7. And the natural mother's view expressed by her solicitor that she was a gold digger and simply out for the money, you could see was fading away in this natural mother's mind. And I said to the natural, would you like to please just tell us what your life was like when you were with the boy's father? And the same thing happened. She described how she was abused, beaten, treated in an appalling fashion. And the foster mother's view of her as a heartless woman also changed. And so they then began talking to each other, which is the first of them done it ever since, probably ever. And so I said, well, look, what are we going to do about this litigation? And I told them something I tell international presidents of large Japanese organizations. I said, what do you think the judge does when he's heard all the evidence and sits in his room, forgive me, Robin, and picks up his pen to write his judgment? I get, just justice, listens to the evidence, decides. I said, when I first started sitting as a judge, which is older than most of before many of you were born, not such thing as judicial training. But Peter Taylor, God rest his soul, who became Chief Justice, was a good friend. I said, Peter, what do I do? He said, Michel, it's very easy. You find out who the bad people are and make sure they lose. Now, international companies pale when they hear this. So, mediation, what's a fair result? So I said to the two mothers, go away, think about what you've heard from each other. And if you want to, come back with a piece of paper which you think is a fair result. And I sat there for half an hour thinking, have I done the right thing? They're going to go back to the lawyers and they'll be furious and they'll be G'd up again. But in they came. I had the 2 bits of paper and they both said the same figure, 50-50. So the media up there had a hand. But again, that couldn't have happened unless I had assured both of them that they could be utterly frank with each other without fear that somebody's going to poke into what happened and what was said and swear an affidavit ordering disclosure of what went on. So, turning, if I may, to the article by Michael Briggs. I'm going to flip through the cases because they're all set out fully in here for you to read. That's the Procter & Gamble exceptions. And these are all the cases which all of you know, I know. And they give indications of how, bit by bit, the courts have opened up the confidentiality to allow evidence to be given on what went on in mediation or disclosure of documents. And we've dealt with that. And this is Lord Briggs. He was then Mr. Justice Briggs. And what he said, the secret or the widespread concern of mediation is that the confidentiality is limited to that conferred by the WP principle. And if attempts to widen it by contract are likely to be ineffective, then mediation will lose one of its main attractions as a dispute resolution process. Absolutely right. And then he said, well, looked at from the outside, it doesn't appear to be any more than the rough and tumble of hard-fought negotiations. But he then says, viewed from the inside, the picture is rather different. True it is the mediator will act as a conduit for the sharing of such information between the parties as is commonly shared in without-prejudice negotiations, which he calls shared information. But an important part of the mediator's facilitative role is to encourage the parties to share with him or her information, views, hopes and fears about the dispute, which the party communicating them does not wish the other party to know, and which the mediator agrees to keep secret. By that process, the mediator becomes uniquely appraised of aspects of the parties' attitudes to the dispute, such as, but by no means limited to, their respective bottom lines, which may enable him or her to promote a compromise route which would not occur to either of the parties, and which sufficiently meets their secret, different concerns to be able to form the basis of a durable settlement. The ability of a mediator to receive mediation secrets from the opposing parties without communicating them across the divide, and to use the knowledge thereby gained in assisting the parties towards a settlement is unique to mediation as a dispute resolution process, and an important part of the success to date in sparing the parties the time, stress, and enormous cost of pursuing their dispute to a judgment. Put in the language of legal professional privilege, it enables the parties separately to unburden themselves to the mediator so as to receive assistance which would otherwise be unavailable to them. And as he rightly observes, none of the courts which have adjudicated in the cases which I've listed and which it will be in the pack has ever approached that particular unique element of mediation. They've simply regarded it as without prejudice negotiation and subject therefore to all the exceptions. And then, as far as I'm concerned, why is it so important now? It's important now because Halsey started the process. If you unreasonably refuse, you could be penalised in cost later. Right through to Churchill, where the court has power to order parties, even if they don't want to mediate. And the court will recognise what the Master of the Rolls called non-court-based dispute resolution processes. It's a bit of a mouthful, but that means that you don't have to go to a lawyer. And those of you who heard or seen any of the skeleton arguments will know exactly what I mean by that. But the other parties have power the courts have power to order parties to mediate. And mediation has expanded to every area of dispute in civil and commercial law. And the expectation of a release from expensive and frankly nugatory procedures. And I've given you the examples. And it may not be sufficient because we also have discussions with experts, sometimes with witnesses, insurers, and principals, and interested third parties. And none of those could be categorized as falling within WP negotiation privilege. And therefore, there is a lacuna. And we need to urge the court. And this is a phrase that I think Kelly rather likes. If parties choose or are ordered to resolve their disputes by mediation, they have a right to expect that the courts will safeguard them from any consequences of fully engaging in the mediation process. That is the watchword for this talk to you. They have a right to demand it, and we have an obligation to fulfill it. We do it contractually in our mediation agreements, and every time I say what I do to parties, that nothing you say, etc., I've got both fingers firmly crossed. Because if somebody asks me, well, what about Procter & Gamble? Or challenges it, I would be in difficulties. I'd have to say, well, contractually, you've agreed to it. But what worth is that? And frankly, we all know that the courts will disregard that if they want to. And they've done so in the past. And so it's not very difficult. We don't have to have a mediation act, although that would be the best thing. But that, I think, would take years, and parliamentary time is not available for such a thing. But just as the Master of the Rolls introduced compulsory mediation in Churchill, completely out of the blue. I think I had one line in my skeleton argument and nobody else mentioned it. But he was obviously waiting for the opportunity, and good on him. And if he can do that for that, he can also find the right occasion to say, as far as this court is concerned, mediation does have a separate privilege. It is a process which is not able to be compared with WP negotiations. It has special features which are unique, which we need to protect. And if we're going to order people to mediate and encourage them in all sorts of ways to mediate, we owe it to them to make sure that if they engage fully, then we will protect them. There are several objections to it, which I've dealt with in the paper, and I'll let you read those later on. I'm noticing how the time is going. And then those three cases are interesting. DKH is the decision where a party was ordered to mediate. Both parties saying no, impossible, all the usual objections, which the judge sensibly said, no, you got until December to do it. And there's a lovely postscript at the end of the report. On the 7th of January, the parties had informed the judge the case had been settled, but he couldn't resist that. A census is the opposite. There, the judge made some most extraordinary remarks. That was impossible. And Tony, I think you put an article on it in the Cedar thing. I read it. Parties are impossibly apart. They never bridge it. They're not in the right mood. I can't see a settlement being achieved. All this inner judgment. Refusing to order a party, or is it on a cost thing? And then Merck and Merck, which again is fully set out. So this is my solution. This is what a distinct mediation privilege needs to have. It's essential that the mediation agreement is in writing. It's got to be in writing, so there's no argument about what the mediator and the parties are committing themselves to do. And also, it's essential that part of that agreement says that there will be no settlement enforceable at law unless it's reduced to writing and signed by all parties. And this is also essential to stop the nonsense of people applying with what I call settler's remorse, to set aside, say, oh, misrepresentation, undue influence, I didn't understand it, the mediator didn't explain this. It's a lawyer's job, when drafting settlement agreement, to include within the settlement all the representations, warranties that your client is relying upon in entering the deal. And it's the mediator's job, when I know what's being said and I know what parties are relying upon when agreeing to the settlement, just to make sure that the parties have included it. And also, when we do mediation training, and I'm sure, Tony, you do the same with CEDA, say to lawyers, preparation. Find out what your client must have out of any settlement. Not like to, must have. And then find out what your client can't possibly live with. There's no way an apology. And also then a list of things you'd like to have. And then part of the training that I'm sure you all do, draft the agreement before you even come to mediation. And if there's something you know your client won't live with, tell me. The one unique feature of mediation we know is the ability of the mediator, unlike a judge or an arbitrator or a tribunal chairman, to speak directly to the parties privately before the mediation and during the mediation. And that is another unique feature which the courts don't actually appreciate. I mean, when I did sit as a judge, you long to be able to speak to somebody, say, hang on a second, but you couldn't. As a mediator, not only can you, you should. And as lawyers representing parties, you may take advantage of that. Use it. It's the biggest advantage you've got, to be able to speak to a mediator privately, not just confidentially, in a privileged environment where what you say will never be exposed to the court's view, but you do your service to your client in the best possible way. And if the mediator knows something that one side can't live with or wants to have, there's always going to be an opportunity for us, when we're with that party, to wean them off an idea which we know is not going to work, or to suggest, steer them towards something we know will work. That's what we do. Now, if that's ever going to be in danger, we're going to be worried looking over our shoulder, looking at our insurance premiums. So that's why privilege is an essential part of the future. People say, well, privilege means you can't sue your lawyer. Of course you can, because we know that if you sue your lawyer, you can't stand on your privilege to prevent the lawyer defending himself. So that's in fact an objection without basis. And Singapore Convention is another matter which there's no time for tonight. And looking at the counter arguments, they're all there. They can all be dealt with. They're all set out. last but not least, I said to the committee drafting the ADR directive, you are leaders. There's no point waiting for people to tell you what they want. You should anticipate what they want, and it's your job to give it to them. And it's the same with mediation. Nobody in this room, so no judge knows as much as you all together in this room about mediation. Our combined knowledge is unique. And if we can't persuade the judges that what we need and what mediation needs, then we shouldn't be doing the jobs we're doing. And never forget, there are three parties to a mediation. There's the parties themselves in dispute, there's the mediator, but possibly the most important party is the process. And it's our duty to protect that process and make sure it survives and make sure it's not eaten away by judges who are keen just to lift the curtain a bit. But this won't hurt. I just need to know this. They don't. They don't. If we do our job properly and lawyers do their job properly, you never need to go into a mediation. If there's a breach of warranty, sue on the agreement. If there's a breach of representation, sue the representation on the agreement. And if it's a breach by the mediator of what he's sworn to do, sue him on the contract you have with the mediator. So all the cases that have been decided were never necessary. And as you will see in the notes, there's even one where a party wasn't even a part of the mediation, applied to the court for the mediation file of the solicitor acting for one of the parties. And Master Bragg made the order. The European directive, under no circumstances will a mediator be called to give evidence. There have been at least 3 cases where a mediator was ordered to give evidence. And one, when it was accepted that the mediator concerned had no recollection. But under cross-examination, it's amazing how people's memories can be revived. That's totally improper. And there's one case where Jane and Arthur in Pharmacist, she fought it, and Viv Ramsey said, no, witness summons stands. Comes out of court, and Jane was telling me this, Herbert Smith, right, can we take a proof of evidence? She said, no, you've called me, you'll take me blind. They settled within an hour. Good for her. But there we are. That's our obligation. That's the future for you all. Have the debate. But is there any really answer? Is there anybody here who doesn't think that mediation privilege does exist? If it doesn't, it ought to exist. Thank you for listening.
Thank you very much, Michel, for a very rich and thought-provoking lecture. If we may, I think we'll pick up that question and other questions that people may have over drinks. I'm mindful of time, but apologies to those who are watching from their homes. So I'll now pass over to Professor Ormerod for some closing remarks.
Thank you very much. It really has been a privilege for the faculty and for the centre to host the Civil Mediation Council's academic lecture. We couldn't have asked for more, for better in terms of eminence of speaker and the captivating delivery. And I'm sure that that will also be borne out by the debate that's been generated outside when we have drinks, for those of you who are able to join us. I think it also underlines so clearly that mediation is mainstream law, which is one of the purposes of the centre and one of the aims of the faculty in terms of integrating this within the curriculum for the undergraduate and postgraduate degrees. So thank you again. It falls to me to thank lots of people, actually. Of course, our speaker, Michel Kallipetis, for a wonderful presentation, really captivating for everybody here and online, I'm sure. So thank you very much again. Thank you also to the Civil Mediation Council team, Kelly, for chairing and I'm sure playing a significant hand in organising. But also Victoria Harris, who is here I know is Chief Executive Officer of CMC, Paula Rathjen, who's the Communications Officer for CMC, and others at CMC, Joe Bearpark and Angela Turley, who are in the Secretariat there. And of course, from our home team, Kat, who is here somewhere, and Lisa Penfold, who played a significant role in organising the event here and online. So thank you to them. And of course, thank you to all of you for attending either online or here in person. And those in person, I hope you will join me in thanking our speaker and then joining us for drinks. Thank you again. Thank you.